Fourth, the VFW remains concerned about the VA disability claims backlog and the VA's current efforts to overhaul its claims processing system. As the Veterans Benefit Administration transforms from a paper-based to an all-electronic system, we must ensure that the laws in place to protect veterans remains intact. The quality of ratings cannot suffer in the effort to move claims more quickly through the system. The Veterans Benefit Management System, or VBMS, has the potential to allow the VA to work efficiently in an all-electronic environment. However, VBMS continues to suffer from processing delays and frequent and unpredictable downtime. As a part of their effort to reduce the backlog and to encourage electronic claims filing, the VA has published proposed Rule A081 in October of 2013, requiring claimants to complete standardized forms before starting the claims process. We believe the VA's proposal will roll back veterans' rights by making it more difficult to file a claim, cheating thousands of veterans out of months' worth of benefits. Under the current law, a veteran can start a claim by sending any written communication to the VA. Veterans then have up to 1 year to complete the required VA forms. If the VA awards benefits, the veteran receives back pay to the date when the veteran first contacted the VA. If the proposed rule goes into effect, an informal communication would no longer serve as a veteran's date of claim unless the veteran files electronically. This does not incentivize electronic claims. It penalizes the veteran who chooses to file by other means. The VFW urges Congress to protect the ability of the claimants to file an informal claim, whether electronically or on paper. In response to the public outcry over the outrageous wait times for waiting decisions, the VA has triaged its caseload to focus on the backlog of disability claims, while neglecting other categories of claims like dependent claims and appeals. Congress must hold the VA accountable for this backlog as well. The VFW recently visited VA Regional Office in St. Petersburg, Florida, where our staff reviewed 79 paper and electronic claim files with rating decisions. What we found was 21 cases had problems or errors. That represents 26.6% of the cases we reviewed. The VA reports ratings in St. Petersburg are, on the average, wrong 10% of the time. We did, while not all the errors that were found there involved ratings, 17.7% of the ratings reviewed were errors. This is significantly higher than what the VA reports. Further, we identified 3 clear and unmistakable errors in earlier ratings. One of these decisions, when corrected, should provide an award of benefits to a veteran dated back to 1985. In addition, the VFW found that raters accepted a number of inadequate VA examinations for ratings. Based on our review, the VFW is concerned that some raters would rather rate a case using inadequate or negative evidence rather than to return the examination to be completed correctly. The VFW will continue to hold the VA accountable for its obligation to process timely and accurate claims, and we plan to make more site visits to assess progress in the coming months.